Hello, everybody. My name's Melissa Leach. I'm director here at IDS, where it gives me enormous pleasure to welcome you all to this year's IDS annual lecture. This is the flagship event in our calendar, and a tremendously warm welcome to all of you, a big audience here in the room in the IDS building, and to all of you watching online. Before I introduce our guest speaker, and I have to say we have an amazing guest speaker and it's going to be a fabulous lecture, I've got a couple of housekeeping points which I should run through. The first is for those in the room, we're not accepting a fire drill, so if the IDS fire alarm goes off, it will be for real. We have a hearing loop available in the room, so if you need to use that, you need to select the setting T. And for those watching online, the closed caption option is available on Zoom. Also, for those of you online, if you want to collect questions in the Q&A function, when we get to the discussion part of the evening, we will be able to respond to those as well as questions in the room. So now, the all-important welcome to our guest speaker for this year's IDS annual lecture, Karuna Nundy. She's come from India to join us today and for a couple of days. She's an extraordinary person in many ways. She is listed by Time magazine currently as one of the 100 most influential people in the world. She's an advocate at the Supreme Court of India, and she's worked with the United Nations and governments around the world on questions of constitutional law and policy making as they apply to questions of rights and particularly gender-related rights. Her latest work has included leading arguments to criminalize marital rape and separately to legalize queer marriage, and doing that in the Indian context, which is challenging indeed. I can't think of anybody more appropriate and inspiring to speak to us this evening, especially in the context of IDS's long history of work on gender and justice, our many current programs on countering the backlash against gender injustice as playing out in South Asia and many other countries around the world, and our long-standing involvement in learning around gender and development in its widest sense, particularly in running the MA in Gender and Development, which has been the learning ground for many, many gender justice activists, academics, and policymakers now doing great things around the world. So, Karuna, I'm enormously happy to welcome you here this evening. I'm going to turn over to you now to deliver your lecture under a superb title around gender justice and joy, legal travels through the patriarchy, suppressed speech and corporate crime. We'll hear from you and then we'll open up to questions and comments. And then you're all, those of you in the room at least, very welcome to join us for informal discussion afterwards over a reception outside in the convening space. So Karuna, welcome once again and over to you.
Melissa, thank you for that wonderful introduction. And it is truly a delight and an honor to be here with you all. IDS and Brighton as well is known to be a nurturing, happy, brilliant space. So I'm very happy to be here. Shall we? Let us begin with love and cricket. Melissa Ferrier and Kamakshi Raghavan met at the cricket pitch in the other Brighton in Australia. And Melissa was clean bowled for the first time. Kamakshi took a little bit longer. Within 6 months, they were living together, deeply committed to each other. And the first opportunity they got, they registered, they moved to the UK, and they registered under the Civil Partnerships Act. They then were married in Australia. But when they moved back to India, because Kamakshi's work and larger family and life took her there, their marriage was not recognized. And then suddenly, this family, with their 2 children, Lara and Arjun Robbie, didn't have family status. So their presence, so Arjun, Robbie, and Melissa's status in the country was in jeopardy. Every year, she had to go to the Foreigners Registration Office and produce documents like a rental agreement with Kamakshi to demonstrate that she had the right to live in her own home. They're pillars of the community, but the kind of dignity that and legality and privilege that their relationship should get does not still exist. I have the honor and privilege to represent them, another couple, and an activist, another couple, Joydeep Blaine, and the activist Mario de Pena, before the Indian Supreme Court in our case for marriage equality. There were a number of petitions before the court. The arguments we brought were that the Special Marriage Act was a progressive legislation in a country where the Constitution demands that we bring not only caste equality and gender equality, but also now equality based on the range of genders and the range of sexualities. We argued that the Special Marriage Act is the ideal law under which the provisions of marriage equality could be located. And why? Because there is a segment of the Act, for those of you who are lawyers, sections 15 to 18, that doesn't need reading in, reading down. It is gender neutral. It recognizes custom and celebration that is outside of religion and outside of anything that's explicitly recognized. And it's the ideal legislative space to locate marriage equality. We argued that if two people have the constitutional right to choose who they marry, then the courts must provide a remedy, because you cannot have a right without a remedy is hollow, effectively meaningless. Before the ecclesiastical courts in Bombay, when they existed, a Parsi man named Kursitji argued that he did not want to be governed by ecclesiastical law. And why was he being governed by ecclesiastical law and not Parsi law? Because when the Parsis came from Iran, a lot of the source texts were lost. So what did the courts do? The case went up to the Privy Council. And the Privy Council is the precursor in some ways of the Indian Supreme Court, although the Supreme Court, of course, is the court of independent India. And jurisprudentially, we sometimes rely, when it's helpful, cases of the Privy Council. So the case went up to the Privy Council, and essentially, one thing became clear, and the courts said so explicitly. We placed this before the Supreme Court, that when two Parsis came to you and they said that there is a vacuum, there is no law, your jurisprudence was clear. What you said was that the legal vacuum cannot take away somebody's fundamental rights, and that the common law exists in order to develop law on a case-by-case basis. In fact, it is the nature of common law to do so. So this is how the Parsi law of marriage would then evolve until legislation came in. There is absolutely no reason that this could not happen with queer couples. Also, the cases were being called the same-sex marriage cases. And the dominant discourse was on same-sex marriage. In fact, even when arguments began, the issues that were being spoken of with this very limiting language. Our petition brought queerness into the discourse, so the relationship rights of trans and non-binary people would not be left out, and gender would take the place of sex. In fact, one of the lead counsel had argued only in terms of same-sex marriage, and they then spoke of how trans people constitute a sort of minuscule minority and a tiny percentage of the people whose rights that we were claiming. And as a result, I opened with the fact that one of my assisting counsel is trans, and the fact that the erasure of these lawyers in the courtroom, standing before the judges, and the erasure of those who are watching, and the erasure of the millions in our polity, is not something that our constitution permits. Here are the headlines. Yes, but no, no, no. No legal marriage rights for same-sex couples, rules SC. See, same-sex marriage, this subsisted in some of the headlines. SC rules 5-0 against same-sex marriage, 3-2 against adoption. What is at stake here? Dignity, rights, the privilege of being recognized as a family, the privilege of the concrete tax, health, provident fund, other legal privileges that you get as a result of being married to someone. Now, the judgment wasn't. So there were 5 judges, and you have to create a sort of Venn diagram when you're looking at 5 judgments, and you have to kind of map out what the majority, what any 3 at least have agreed on, right? All 5 judges agreed that they couldn't enable queer couples to marry, and that such law was in the domain of Parliament. Now, remember Kursidji, and how Kursidji's rights were not in the domain of Parliament. And Kursidji was enabled by the courts for his marriage and for the marriage of Parsis to be, for the law to be developed in that regard. That concrete steps must be taken to protect queer couples from violence, and there were various provisions that were set out on this. The court also agreed that transgenders of the opposite gender can marry. So if I am a trans man and you're a trans woman, then we can marry. Or if I'm a trans man and you're a cis woman, we could marry. That's one of the issues that we had argued. And the Chief Justice in Justice Sanjay Kaul held that queer unmarried couples should be able to adopt as parents. Now, this was quite significant. Single people can adopt, but the parental role and the parental involvement in rights and the rights of the child of the other parent then gets set aside, gets obviated. So where do a lot of these attitudes come from? This is Lord Matthew Hale. And Matthew Hale dreamed up the idea that you cannot rape your wife. He wrote various criminal treatises, and a lot of these ideas around gender, sexuality, and queerness actually come from the Indian Penal Code that came into being in 1860. Now, this is very much based on Victorian morality, colonial suppression of speech. It includes the law on sedition, under which Gandhi was tried, Mahatma Gandhi was tried. And it also includes laws like Section 298, which you can't make a sound that offends the religious sensibilities of another person. Now, why were why was this structure of law brought in? In part because of the Victorian morality that subsisted at the time, but also very clearly because of colonial control of the population, the suppression of speech, but also the keeping all the different religious and other communities happy without interfering with the power structures within those communities, right? Because it's not in your interest to mess with that. Let them be separate and peaceful. So Lord Hale's treatise on criminal law, it's the Hale Doctrine, and the marital rape exception traveled through the East with colonialism to India, Pakistan, Bangladesh, Malaysia, and Singapore. And it's interesting because if you look this up, in most of these countries, it's the same section, section 375. We'll come to that. And it traveled through the West to the United States and to the Philippines, meeting in Southeast Asia. And this historical odyssey has left us with a huge amount of legalized violence in its wake. I'm writing a paper at the moment with Professor Susan Osterman at Notre Dame, and we are looking at the travels of Hale's ghost, because it is, in the end of the day, it was a very powerful meme, right? A meme that traveled along very entrenched and powerful structural avenues. Today, in states like Virginia, if the husband agrees to therapy after committing marital rape, he can avoid criminal charges. In South Carolina's laws strictly state that the married victim has only 30 days to report the rape and must prove the threat of physical violence. Or even worse, in Nevada, simply being married to the victim is enough to protect someone from prosecution. So who can tell me when marital rape was criminalized in the UK, in England? Not in the 1970s, that's not correct. Louder? 1991. In the case of R versus R, in 1991, the marital rape doctrine, Hale's doctrine, was set aside. Today, it is the lions and not the hunters that must write our own laws and that must write our own histories. Some of you will remember in 2012, the assault and gang rape of the young woman who was called Nirbhaya on a bus. There was a rising in Delhi and in the rest of the country, in South Africa, in Steubenville, in many different parts, in the US, and in many parts of the world. It found resonance with a global polity of women and allies. On the back of that, it became clear that there was an opportunity to decolonize the law and significantly to deconstruct the patriarchy in the law. So what was achieved? In 2013, there were crimes peculiar to South Asia: acid attacks, disrobing, and that's a crime against Dalit women primarily, that we were able to bring in. Stalking, which exists around the world, but it's valorized in Bollywood films. And in fact, when the law went to Parliament, we tried to, what was on paper was that it would be a non-bailable offense at the first instance. What a non-bailable offense is not that you always get denied bail. What it means is that it's up to the decision maker, it's up to the court to decide whether or not you will get bail. Or if you do get bail, that they can impose conditions, because if it's bailable, the judge cannot impose any conditions. Remember that stalking is something that constitutes a repeated following to even qualify as stalking, right? In the face of non-consent. And a politician, a member of parliament, stood up on the floor of parliament and said, but we did that in college all the time, right? And stalking became a bailable offense. Another achievement was Section 166A, by which we had penalties against police officers who do not register sexual crimes. And you could prosecute a police officer for not registering the crime without the permission of the state government, because getting the permission of the state government was like waiting for Godot, it never came. What remained on the books, even though the Verma committee, the jurist committee that had been set up by the government after the uprising, had recommended that marital rape be done away with, that those of us lawyers who were working with the movements and working with the government in order to get the ordinance that they had passed, the quite draconian ordinance that they had passed, into good law, we recommended strongly the removal. We tried to have the marital rape exception removed, but this remained on the books. So what is it? A man is said to commit rape if he penetrates his penis to any extent into the vagina, mouth, urethra, or anus of a woman, or makes her do so with any other person. This is important, right? And then it goes on to speak of other objects or organs without consent being inserted into the orifices of a woman. The second part of that provision deals with different kinds of consent. Explanation 2 is important because this is something that we were able to get into the law. And it says that consent means an unequivocal voluntary agreement when the woman, by words, gestures, or any form of verbal or non-verbal communication, communicates willingness to participate in the specific sexual act. Why is this important? Can anyone answer that? Put your hand up. Kind of. Because this is now a yes means yes jurisdiction, right? Because the consent must be unequivocal and voluntary, and the willingness must be communicated. Now, it could be through words or gestures. It could be verbal or non-verbal, but it's still a yes means yes, right? Also, a woman who does not physically resist to the act of penetration shall not, by reason only of that fact, be regarded as consenting to the sexual activity. Immediately after, though, you get to exception 2. Sexual intercourse or sexual acts by a man with his own wife, the wife not being under 15, this is now changed. It was 15 in 2013. It's now 18, is not rape, right? So if you are married and over 18 and your husband penetrates an organ or object into one of your orifices or causes another person to do so, then that is not rape. From 2015, we started petitioning the court, and arguments went on with lulls in the middle, not continuously, but for 6 years. there was a split bench, and one side agreed with us, the other did not. In fact, the same week that the split bench decision came out, the Dobbs versus Jackson decision in the United States that said that abortion was not a fundamental right, the leaked Alito decision of that bench came out. And both went back to Matthew Hale. So what are we faced with today? We're faced with then unreconstructed Victorian patriarchy, a backlash against the rising of women and queer movements, of patriarchy repackaged as victimhood. We are in the Supreme Court now to challenge, to ask the Supreme Court to make a decision that the question of law that has been thrown up, and I phrase it like this because of procedural, the way procedure works. And also, I have been working with judicial academies in order to work with, as a resource person, to work with judges so that we can together understand the fact that you cannot kill your wife in the bedroom, but this also, you can't slap your wife in the bedroom. You can't also sexually assault your wife in the bedroom short of rape, because there's no exception there. And it's very important to remember that, because these crimes can be brought into play when this one fails. So when we decolonize, what do we deconstruct into? How does law and policy then emerge? Dr. Ambedkar said, to leave inequality between class and class, between sex and sex, which is the soul of society, and to go on passing legislation relating to economic problems is to make a farce of our constitution and to build a palace on a dung heap. There is a new penal code that has been brought in. It's called the Bharatiya Nyaya Samhita, and it is an attempt, it is purportedly an attempt to do this. The sedition law by which the British colonial governments tried Mahatma Gandhi is the same. The marital law, rape law is unchanged. 85% of the Victorian Penal Code is identical. Now, I think it's important also to think about decolonization not being just along a single axis of power. It can't just be about overthrowing imperialism and buying into ethno-religious fascism or the heteropatriarchy or casteism, because you're just trading one set of oppressions for another. So when we decolonize, and let's have a larger discussion about this after, but when we decolonize, to step in to more granular ideas and of freedom and enabling is fundamental. Around the world, we see a backlash. In September 2022, Mahsa Amini was arrested in Tehran, and Iran's morality police, tasked with detaining people to promote virtue, arrested her for wearing her hijab in an improper manner. She died 3 days later. There have been inspiring protests by the women in Tehran after this. Over 100 journalists have been arrested for even reporting on these protests. But in September 2023, Iran passed a new hijab and chastity law. This is even harsher. Totaling more than 70 articles, the bill defines an array of financial penalties for hijab violations, which could be ramped up to prison terms if found to be done in an organized manner and in contact with foreign governments, networks, media groups or organizations, or people affiliated with them. Business and business owners will also be exposed to punishments, including hefty fines, bans on leaving the country, or prison terms if they found to be propagating nudity, lack of chastity, or bad covering in any way. So how is this even stricter, even harsher than the laws that came before? It's because they have got the core offenses, and they have also covered the core offenses with a number of speech offenses, with a number of association offenses, and limited the freedoms around them in a vague way, in a vague manner, which has a huge chilling effect, which then means that there's a penumbra of quietude around these freedoms. Uganda's penal code already punished same-sex conduct with life imprisonment. It was a criminal offense that was rarely prosecuted, but the new law creates new crimes, such as the vaguely worded promotion of homosexuality, and introduces the death penalty for several acts considered as aggravated homosexuality. It also increases the prison sentence for attempted same-sex conduct to 10 years. A few months ago, some of us on the high-level panel of Media Freedom, which is an advisory body to the Media Freedom Coalition of 50 countries. This was set up by the UK government, and now it is the Canadian, there are other governments that are leading the effort. But I had worked on an anti-blasphemy report, a global report on religious freedom and discontent, the report on international standards and blasphemy laws. And we did primary research looking at blasphemy laws across the world. We looked at what works, what doesn't work, the patterns of spread and how hate speech and blasphemy are conflated in a way that is sometimes not useful. That under cover of blasphemy, sometimes hate speech goes unpunished. So that's something we're working with various governments at the moment to effect policy change. This was also the basis of a MOOC, training of judges at the Bonbero Institute at Oxford, where we're training judges and policymakers on international law and how they can and should deal with blasphemy across the world and in their own jurisdictions. By Friday, this is my wonderful legal team that through difficulty, through backlash, we walk on. By Friday, we will file a review of the marriage equality case before the Supreme Court. On the 7th of December, we will seek a hearing of the marital rape challenge before the Supreme Court. Gains are made nowadays in small measure, and sometimes it's 3 steps forward and 2 steps back. But if the women's and queer movements have taught us anything, it's that the personal is the political. And that we practice for the hard times, and as we work to bring rights revolutions to decolonize law, not only from our imperialist shackles, but also from those of misogyny and caste and fundamentalisms. And even if in small measure, we will keep walking with hope tempered by realism and most of all, joy. Thank you.
Karuna, thank you so much. And what an important note to end on, because I think as we look around the world that we're living in, which is full of crisis and disaster from all fronts, and we think about that a lot in development and development studies, that sense that there is hope out there, and how can we build a politics of hope, as we often put it, is incredibly important. And I think you've shown us both the importance of doing that in this particular area around deep gender injustices, but also some of the very practical ways in which that can happen, and the ways in which the law and the legal professions and law-related activism can be such important tools in those struggles. So that was fantastic, but it's also, I'm sure, opened up many, many questions and comments. So why don't you have a seat for these if you'd like, and we'll now open up to the floor. And if people in the room, we'll take a few questions at a time. If people in the room could raise their hand, and we will need to go round with the roving mic, and we'll take a group of questions from the room, and then we'll move to taking some online. So if our online audience could put their questions in the Q&A, we'll get to you in a moment. So we've got one we'll go to the back, and then we'll come here. And if people could just briefly say who they are, that would also be helpful as you ask the question.
Hi, my name is Philip Proudfoot. I'm a research fellow in apparent popular politics. And I have a question about legal systems. I work a little bit in the Middle East, which has a civil law system. Lebanon, the law that persecutes homosexuality, Article 534, says sex contrary to nature, which has led progressive judges to reinterpret it occasionally, which gets very bad press coverage of homosexuality is now legalized in Lebanon because people don't understand it's not common law. So I was wondering, do you have any, and then you mentioned Iran. Iran has a combination of Sharia and some aspects of civil law. So I was wondering if you have any reflections on how the overarching legal system affects spaces for this sort of legal resistance. Thank you.
Yeah. See, that's really... Oh.
Are you happy to take a few, or is that sufficiently detailed that you'd rather come back on it straight away?
I'm happy to come back straight away.
Okay, good.
Look, I think that the civil law, common law systems are converging to a significant extent, right? So the differences aren't as great as they formally appear to be. But the language of the provision that you just mentioned is actually very, very similar to Section 377, which spoke of unlawful carnal intercourse against the order of nature, right? Which, as you quite correctly say, leaves room for interpretation, but is still hugely oppressive because it's the sword of Damocles. What kind of judge are you going to get? How are they going to interpret it? Is the police, and this is what was happening in India, is the police going to wield the oppression that's possible in the interstices of interpretation, right? And thereby pushing people into hidden spaces. So, of course, it matters whether it's a civil law country or whether it's a common law country, because if it's a civil law country, then the change in the law means that there's a lot less discretion, right? And there's also examples of change in Sharia law. There's not in this area as much, but in other areas. So I presented a paper to the OIC, the Organization of Islamic Conference, on behalf of the UN with regard to children's and women's rights, and as interpreted by strands of Sharia that were meeting international human rights standards, things like the Cairo Declaration, etc. Right? And what was interesting was that when you speak, for example, of stoning, right? And stoning is something that there isn't so much room for interpretation, but in terms of the process of getting there, you can make that hard. Are you looking at Malaysia, or are you looking at Saudi Arabia? You know, so Sharia judges have these choices. And when I was working with the Maldives Supreme Court and advising on these issues, this was kind of the range of play that they had. This was kind of the area that they were working in.
Right. I'd like to, perhaps we'll just go along to Rosie next, Philip, and then we'll.
Hello, I'm Rosie McGee from the same cluster as Philip, Power and Popular Politics, and I also teach on our MA in Power, Participation and Social Change. Thanks for a really inspiring talk. I wanted to pick up on a question that came up in class recently when teaching on social change and the nature of social change and the relationship in a social change process between changes in formal institutions and changes in informal norms and customs.
Yeah.
And I just wondered, as a lawyer who has worked so much on this subject, what would be your commentary on, for example, the changes which you're pushing for in India and the readiness of norms at the more informal level of the population and what the relationship should be ideally between those two in order to make for a sustained change and not a change which is going to lead to backlash or pushback at some point?
Excellent question. So the way I think about this in the context of marital rape, for instance, right, is punishment, deterrence, and norm shifting, right? Now, in Pakistan, after the Hudud laws were repealed and the criminal law was amended, marital rape is now a crime, but not one person has gone to court, right? In India, you have a tiny percentage of people that go to court even against stranger rape, right? There's one thing that a lot of people are going to go to court, no. But the criminal law and its structures must be available for those who can go to court and who wish to go to court and do have the wherewithal to do so. The deterrent effect must be present, because even if it means that the police officer can have a chat and you can leave it at that, that's quite helpful. But the norm shifting is also very important. When I've argued this case now 3 times anyway. But one of the rounds of arguments, you know, those sleepless nights, and I had someone supporting me with my care responsibilities, and I was chatting to her, and I always explain what I'm doing and what people are enabling and helping me to do, right? And she said, and this was an older lady, and she said, marital rape, that's even a thing? Like, but then why would people get married? Right? So I think the norm shifting is something that's quite important, because if you can, and if it's explicitly legal, I think, you know, that provision is particularly shocking, and you would think that because of that it's low-hanging fruit, and it's not. You have men's rights associations that, you know, send rape threats and death threats and are very well organized and leverage traditional patriarchy and repackage that patriarchy as saying the feminists are after us, right? And come with a lot of violence and power. So, yeah.
Yeah, good response. So I had a question at the front here.
Yes.
I just wait for the microphone. Actually,
We'd love to see you, but whatever you're comfortable with.
Yeah.
So first of all, thank you so much for your talk. I think it's really important to mainstream conversations about caste and carcerality, and I think that really came through in the lecture. I'm Chandni, I'm from the MU Gender Program.
Okay.
And I am an abolitionist, and I strongly believe in an abolitionist future. And from what I know of your work, I do think that you share the tendencies, because you've said in the past that if we put people through the criminal grinder, it breaks families, they go bankrupt, it affects employment. And you also strongly believe in the process of mediation as a lawyer, which are both tenets of abolitionist practice.
I feel like you're shaping my trajectory. Go on, Chandni. Good stuff.
And with the recognition that in the Indian context, or perhaps even in the South Asian context, that most of those who are imprisoned come from oppressed caste backgrounds, and most oppressor caste men will never be imprisoned under the amendment bill, for instance. What does a future that is not centered on carcerality look like when we recognize that punishment of imprisonment is not an effective deterrence? In fact, In many cases of rape, what eventually occurs is murder as a means to destroy evidence. So what does that anti-carceral future look like, and what might we do? I know this is not probably the most practical
easy
question.
questions, eh, your students?
But yeah.
What do you expect?
Thank you so much.
Well, so let's give this a shot. Let's think about it together. And other people who have thoughts, please raise your hand. Look, the juvenile justice legislation, right? And the juvenile justice principles shine a light on what a future could look like. So there is the ideas of, for instance, restorative justice. The ideas, and restorative justice is looking at crime and damage from the perspective of the victim, and placing the victim at the center and restoring the victim back to where they were, right? But also in some cases where it feels safe and it's advisable to have a conversation between the victim and the perpetrator, and not in all cases, certainly not in rape cases, most likely, right? With relevant members of the experts, specialists, members of the community around to support the process. Now, the reason that we have this in the juvenile justice system is because of reduced responsibility. So, and mens rea. Mens rea is the intent to commit a crime. The actus reus is the act itself. So, until you're 7 in India, you have the capacity to commit a crime, because you don't have the capacity, even if you kill someone, right? Because you don't have the capacity to formulate, your brain doesn't have the capacity to formulate the requisite intent. Between 7 and 12, there's the Doli Incapax presumption, which is that it's a rebuttable presumption of incapacity. And then between 12 and 18, because your brain is still, and actually there's lots of science to say that this goes up to 25, and Mitt Romney tried to change the law, and there was just a huge backlash, so he didn't. Your brain is much more plastic. It's much more amenable to pressures. It's much more amenable to change, right? So, which is why you have this kind of restorative justice and rehabilitative approach in the juvenile justice system. And this is why you don't have it in the carceral, the straight up carceral adult criminal justice system. I would want, I think, to base any explorations on pilots and data and experiments. Rape is known to be a crime with very high recidivism, right? So it's very hard to deal with in that regard. So it's not a one-off and, oh, I'm so sorry, and, you know, I'll be a good citizen going forward. But I think if we set up these pilots and we understand that this sort of binary between criminals and the rest of us is entirely false, and nowhere does it become more clearer than in marital rape, right? Because people are always trying to, talking about in very emotive and loud terms, throwing people into jail, and the rape is always elsewhere. So after the Nirbhaya rising, I did many interviews and talked about it. I'd also talked about it with communities, talked about it on public platforms. And in the villages, they would say rape is in the cities, right? In the cities, they would say it's the migrants coming in from the villages. In England, they would say it's in the developing world. So in fact, I had a journalist, looking to help these poor Indian women, sort of privileged white male journalists. And whereas there was a woman who wrote about this in The Independent at the time, I wish I could remember, Laura or something. And she wrote this very powerful piece about how it resonated with her, because one of the achievements of the Indian women's movement is that the word of a prosecutrix is given the same status as any other witness. You wouldn't think that this is an achievement, but it is. It means that our conviction rate is at about 25%, whereas the last time I checked, which was a few years ago, the conviction rate here was 3%. The conviction rate in France was 7%. So we have a problem, yes, with carceral methods, but we also have a huge problem with crime, right? You can't look at one without the other. And so when we look at societies that have less crime, I think that's another way to look at getting rid of the carceral system, right? To have societies with less crime. But also, as you quite correctly said, to run pilot projects, to look at how our carceral systems can be non-discriminatory at the first instance, but also truly restorative, truly rehabilitative, right? Any other thoughts on this? Because it's an interesting.
Yeah, perhaps one at the back here.
Let me bring you the mic, otherwise you can the mic.
Thank you. Now that you're talking about restorative justice, I've worked for
What's your name and what do you do?
Jose Alejandro. I'm a student in MA Dev in development. I'm from Panama, and I've been working with the juvenile detention centers for 4 years.
Oh, right.
Yeah, and what you're saying is very profound, and it is alive in our juvenile detention centers in Panama. And we were researching about this. Not only it had an effect on the kids. When you're looking at cases in Mexico, they have restorative justice cases in adults, and their reintegration rates are way higher. So even though their brains are not plastic anymore, it does have an effect on how they behave inside the cells and outside the prisons. So it does make a difference to take this approach, even though they are an adult right now.
That's very interesting.
Very interesting, Kate.
That's it.
So let's perhaps turn to our online audience. Gary, have you got a couple of questions there? Yeah. Wait for the microphone.
Yes, considering the lack of change brought in regards to same-sex marriage in India compared to foreign countries, how would human rights laws in India introduce a possible change to this issue? And how can people push for this change?
As I said, we walk with hope and we walk with realism. And so we do have a review that we're going to file on Friday. And if you want to express your view, get out on the streets and have your voice heard. Write an op-ed, upload a video, call your mother and your grandmother and ask them to come out onto the streets. Ask them to talk to their friends, right?
One more here from Susie Jolly. How can we better take on the anti-gender movement?
Here's the thing. Feminism serves men. Right? 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 I just think that, like, you really want to be stuck in a box of not getting paternity leave, not being allowed to be a proper hands-on father, not being allowed to cry, having to be tough and strong and, all the time, having a part of you that's effectively deadened by society because you're not allowed to give it play. Do you want to always be the main breadwinner and not have help with that? And not to participate in that equally? Who wants that? The reason I think that in India, the queer movements and the feminist movements have been so closely intertwined. And this is why we speak of the heteropatriarchy, right? Because it's a part of the same stuff. It's the same oppressive labelings, boxings that put us into these limited spaces and expect us to behave in very particular ways, rather than just being ourselves, just being humans, just being people. So yes, feminism benefits women more, right? This is true. Queer movements benefit queer people more, but they also benefit men and cishet people, because it opens up the world for all of us to experience the gender spectrum, to experience the spectrum of sexualities, to experience and, to breathe a sigh of relief and experience the world on our own terms. Who doesn't want that? Yeah. And I think that we need to support our men and boys in order to flourish in an environment that enables people like Andrew Tate and Jordan Peterson, because people are lost. I think that there's a sort of backlash of these kinds of masculinities, because I think a lot of men are lost, a lot of white people are lost, and in terms of figuring out what it means to have privilege, but also to exist as a human being and flourish as a human being. I think we need a lot more work and a lot more leadership around that, because a lot of our girls, not enough, but a lot of our girls are being raised to be strong and nurturing and kind and achieving and all of that, right? Yeah.
Come to this question here.
Okay, thank you. So in regards to the position of the law, I want to understand what you're working on regarding the inclusion of the LGBTQ people in the workforce. So I want to know how their economic involvement in India looks like, because for us over there in my country, they hardly get jobs, they hardly get taken into jobs. Recently, I entered for the Commonwealth Short Story Prize for Fiction, and I tried to focus my storyline on the inability to get job in corporate setting. Many of them go into personal work, like trying to set up something for themselves, become makeup artists and something, because they are hardly accommodated in corporate setting. So I can hardly point out 1, 2, 3 of them that are involved in working in corporate setting, in official jobs, apart from entertainment jobs and the rest, things they create for themselves. So I want to find out from you, do you have statistics as to the employment for LGBT people in India? And what work are you planning to look towards the direction of advocating for their inclusion, accommodation into the workforce? Because I think there is need for laws around that. I know someone that lost his job because he did like this as a media personality, and he's a guy. He lost the job. Thank you.
So one of the things that we need very badly, and one of the things that Justice Kaul's judgment spoke to, was an anti-discrimination law, right? And a law that makes sure that you aren't discriminated, one isn't discriminated against on the basis of one's sexuality. I think maybe what you were speaking to was affirmative action, and that's not something that's really happening. But non-discrimination is very much a priority. I do workshops with corporates, with Bertelsmann, with Penguin Random House, with other corporates, around the prevention of sexual harassment law. Now, what this law requires is that in any workplace that has more than 10 workers, you have to have a policy, you have to have a committee that enforces this, and you have to have workshops. Now, I love these workshops because in the workshops, we look at the various issues that men face, that women face, and that queer or non-binary people face, whoever wants to be part of that group. And the feedback that and then everyone listens to each other. I mean, they only invite me if they really mean it, right? The workplace. And so what we do is that we encourage them then, the workplace, to frame an equality policy, not just an anti-sexual harassment policy. Because surely if somebody touches me and says, oh, hey, baby, and that's addressed, but if somebody yells at me and says, you're useless because you're a woman, and that's not addressed, that makes no sense, right? Or if somebody deals with me in a particular way because I'm a cishet woman, but deals with me in a different way because I'm a Muslim woman or a Dalit woman or a trans person, right? That shouldn't be okay. So even without the law, there are these policies that some progressive workplaces are framing to make sure that it's not just the individual flourishing and health of the worker that's being protected, but also the bottom line of the workplace. Because when you're not thinking about all this rubbish, right, you can actually do what you went to do. I think you had a question. Yeah.
Thank you. Yeah, so I'm Jörg Redstrom. I work on this program, Countering Backlash, with some colleagues here. And my question was sort of in response to your response to Susie Jolly's question, how do we deal with this kind of backlash that we're seeing? And you've been talking earlier on in your talk, you talked about the deep history of where this comes from in the law. And later on the points about this as a kind of a male backlash, a male entitlement, which is certainly very strong in it. And I'm generalizing here across not just India, but in so many countries. Yet I feel that, sorry, I had so many questions, but I'm kind of trying to get in a direction that, yes, so feminists and queer activists have the personal is political, and a lot was learned, for example, through the HIV response, including in India with the Lawyers Collective and the NAS Foundation and Sangram and others. And it was very personal and political, but it was very technical at the same time.
Yes.
It wasn't actually very aligned with feminism at the time, but that came later. But you also spoke of caste and class. And I think it's striking that so much of this backlash is tied up in caste and class. And that, so we have cases of Dalit women's rape and being hung and really atrocious crimes who don't solicit the same public response. My view is that to deal and understand and deal with this backlash, we really have to see it as something much bigger than about gender or even sexuality. That's always there at the heart of it. And it's always patriarchal, actually. So we need to figure out how we deal with class and gender and sexuality simultaneously in relation to law. And I guess that's a tricky and, structurally complicated issue. In some ways, the law is useful and simple because we can deal with individuals with absolute rights. But we're dealing with, in terms of the earlier points about social norms, we're dealing with inherited structures of power in classes and castes and sexualities and so on. And on top of that, we have faith and religions, which is what inspired those 17th century puritanical English lawmakers to give us laws that are now traveling or since traveled in empires and we're still grappling with. Yeah. So we need to somehow unpack that deep history of how class, gender, and class, sexuality, and gender, of course, in which caste and ethnicity all comes in. So I've just painted a really complicated picture, but my answer to Susie's question then would be, we need to acknowledge that the backlash itself is much bigger than gender and sexuality, but it's always roped up in it. And feminists are always targets, queers are always targets. And we need to understand how that sits within the broader authoritarian ethno-nationalist politics we're seeing spreading over the world. On that depressing note,
would a question version of that very important set of remarks be, how intersectional can the law be?
Yeah.
that's a much better way of putting it. Thank you.
I mean, is the legal system set up, positioned?
Why you're a
to
fearless
deal with
leader.
These intersectional dynamics.
I think it is. Here's why. Because I think sometimes it's a drafting problem, right? And there was a lot of conversation around this in the queer marriage case, because there were some of the judges were saying, look, aren't we going to be limiting women's rights, right? Because some of these laws are framed, for example, in divorce with alimony, etc., in ways that are not gender symmetrical. And actually, there are ways to, language is a lot more stretchable than it seems. And to the extent that we can stop thinking in silos and start thinking in drafting that is informed by these streams of consciousness and justice and representation, right? I don't think it's a difficult thing to achieve in the way we think about it. I think the much harder thing to achieve is bringing the power structures, sort of leveraging the power structures in a way that these issues get addressed, right?
It's in mine.
Thank you. Hi, I'm Maya Onithan. I'm an anthropologist, and I've been working with legal aid NGOs in India on reproductive and bodily rights.
Right.
My question is, I've been quite impressed by what has been termed judicial activism in India. So a lot of the people like yourselves and others have got together to essentially to shift the discourse on these issues. But it has been recently seen that sort of judicial activism is seen as overreaching itself, and that actually innovative norm shifting laws should actually be coming from Parliament, is what a lot of people are now saying, because we only interpret the Constitution, but the laws are actually made by Parliament. So and this is particularly working around the abortion laws and the recent case around abortion, that this woman who
the 26 weeks
one, and the kind of toing and froing around and the delay in the time that actually justice was not delivered to her and she went beyond the 24 week sort of law. So thinking about that, I was just wondering whether, to what extent you find that a barrier in your own deliberations, because as you said with the Parsi case, there was no law and as such. So I'm just wondering, in terms of this marital equality law that you're putting together, to what extent do you see yourself as limited in moving that forward, in addressing these issues, in promulgating it?
That's an excellent question. So, look, where different countries draw different boundaries around where the judiciary stops and where parliaments, the extent to which parliaments have free sway, right? And in India, at the moment, the law is that the basic structure of the constitution implies that should a provision of law or a law passed by parliament be unconstitutional, then a constitutional court must strike it down, right? However, the courts cannot create law. And this is where there is no PowerPoint anymore. This is where the courts said, we can't create law, so we can't rule in your favor, which is why, very briefly, the point that I was making was that you don't need to create law. The Special Marriage Act is actually, sections 15 to 18 are gender neutral, right? And if you can read it in a way and you can save it unconstitutionality, then do so. So, but as I said, it also depends on the particular nuts and bolts of each constitutional democracy. So when I was in law school in Cambridge, the Human Rights Act came in. And what we were always taught was that classic canard, that if Parliament said that a blue-eyed baby, all blue-eyed babies should be killed, then the courts could do nothing about it. And then when the Human Rights Act came in, then that was something that was a hard stop to that kind of parliamentary sovereignty, right? Which of course then now there's been a huge debate over that and it's very contested. But and the argument there, I mean, the very robust argument around unwritten constitution parliamentary sovereignty was that if it ain't broke, don't fix it, right? And it does work in many ways. But as I think the first question, the first person who spoke was saying, these are very granular questions around what issue it is. They're sort of hard technical questions. They're questions around boundaries, and taking a step back, the political legal discussions around this have shifted dramatically because, of course, the government of the day in India is very clear that they do not want the courts to decide these questions and they want to legislate or not legislate everything, right? So that's where some of this conversation is coming from. Yeah.
I think we should go to our online audience again.
I have a question regarding how foreign policy can affect legislation in countries from the global south. During my research in modern slavery and trafficking in West Africa, I have encountered multiple stances in which activist groups denounce how governmental policies to persecute enslavers aren't applied in order to save face and maintain flow of foreign aid coming in. How would you look at this issue? And is this something that you have encountered in your practice as an advocate for women's issues internationally?
That's a good question. I think that foreign governments will almost always prioritize not just their own people, as they must, but also their own companies and the interests of their own companies. So when you have questions of free speech or non-discrimination or other values that are so deeply important to the French Republic, for instance, and if there is Rafale on the other side, they will always prioritize Rafale, always. They may a little bit on the side have a few conversations and say, could you, maybe, possibly, right? And that's it. So I think it depends on what else is at stake, but what I've seen of governments over the last, I've been at this for a while now, over the last just about 20 years, is that the interests of other countries isn't so much of a thing. So where does that leave us? I think that hard though it is to imagine, in this world of rising sovereignties and in the current atmosphere of extreme impunity that we haven't seen since possibly before the Second World War, that there is no option but to do the hard work of building up international norms and the power to enforce international criminal law, to act against war crimes and crimes against humanity and genocide, and to set norms. That means that the rule of law will be respected, because we see a rollback. And in the recent weeks in Palestine and Gaza, we have seen the huge rollback of international law and of the legitimacy of the Universal Declaration of Human Rights, of the legitimacy of countries to speak for these values.
Right. I'm going to take one more online, and then I want actually just to take a quick group because we're running out of time. So I'll take a group of comments then and then ask you to come back on them. Okay, no more online. Right, so Petra, I think if I take a few and then come back on them.
Try and be concise. Hi, my name's Tessa Lewin. I'm a research fellow here. I work on child rights and also gender rights and sexuality. I am really looking forward to your article on the ghost of Matthew Hale, because I think we need more kind of granular case studies that evidence contemporary hierarchies of oppression as Victorian artifacts from different geographical locations. And I was taken with you saying that this is not something that our constitution permits.
Yeah.
And thinking about leveraging different institutions of the judicial system against each other in the context of anti-gender politics, I suppose. And I was wondering to what extent in India the constitution is thought of as an indigenous artifact, given the discourses around kind of gender as a colonial artifact. And I was wondering, because I think there's something really interesting in that. I'm also South African, so there's quite a lot of resonances around.
Yeah.
I'm going to take a few now because we just want to get around the rest of the people in the room. So if we go to the back.
Hi there, my name's Lou. I'm a second year PhD student here. I research gender-based violence social media activism in South Africa as well, because that's where I'm from. And I'm looking at how it can influence offline policy potentially to make GBV activism better. Outside of that, I run a online social justice education group. And part of what we do is advocacy on the ground as well, so that the online translates into the offline. And something you spoke about a lot was decolonizing the law. And I work a lot with queer communities, being queer African myself, ethnically being from a country where being queer is criminalized. It's something very close to my heart. The usual argument that you get when you go into particularly legal spaces. So I guess what I'm asking is maybe for a more practical advice is obviously the usual argument and sentiments that you don't just get across African countries is queerness is a colonial import. So that's why we won't recognize it. Something I found lately though in my work is even in spaces where queer identities are then recognized, there is no cognizance of the contextual queer identity, if that makes sense. It's very much articulated using Western-centric word. So then I find myself operating already against the idea that the existence of queer individuals in my context is colonial. And then I'm still having to advocate for my community, but within parameters of coloniality, while still having to actively be intersectional and decolonize, which brings on burnout quickly. But then I also find it cannot bring on the safest and the most sustainable solutions for queer individuals in my context. Again, I mainly work in African contexts. From hearing what you said earlier, particularly about having to work with decolonizing the law and stuff, I just wanted to know if maybe you had practical insights into navigating that.
Okay. Right, I think one more over here. No, it's the gentleman there in the back row there. Yeah.
Hi, my name is Niranjan. I had a question about decolonization and the co-option of decolonization narrative in India by Brahminical entities, especially like Supreme Court lawyers who are very popular. They're like Indian Andrew Tates on YouTube, and how there is a question of a new constitution. We're using the same argument about how the current constitution is very Victorian, and how legitimate is that threat of this co-option taking place, especially legally.
Right, and finally, one more, we'll come to you. And then I think we're going to have to call it a day on questions if we just keep it brief.
Hi, I'm Chloe. I'm doing the MA Dev. I am a lawyer, but not in the area that you are. But I'm interested in the law. You talked about patriarchy and the rules. We heard about the history. But it's interesting, isn't it, the patriarchy in the system? So I'd be interested to know from you how you see women in the law advancing in India, particularly perhaps the representation at the high level, which probably if it's like the UK is not great, but also sort of further down, and whether you see women coming on in the system as a key element in making progress, if you like.
Great. So for, again, rather large questions,
Yeah.
if you can just give us some quick thoughts on some of those.
Okay, quick thoughts so we can have longer conversations outside and everyone else can have a cup of tea. So the South African Constitution, there's so much I think to learn from. It's a great constitution, right? There's so much to learn from your right to housing, from the way in which a lot of the rights are articulated, and there's a sort of strong relationship between the jurisprudence of our two courts. Look, I think the Constitution is something that, and I'll club these two questions together. I think constitutions are a product of who contributed to them and who drafted them, but they're also a product of how they were then subsequently claimed and what it then meant to the polity after. And we were talking earlier about a period in our contemporary history where some of us were reading the preamble to our constitution in massive groups, in the groups of thousands sometimes. And the level of empowerment, joy, community that brought was incredibly special. So I would say, even if we refer to these constitutions as artifacts, we must refer to them as living creatures, right? Or living, I mean, I hesitate to use the word artifact with the word living, but it must be a living document. It must be a transformational document. It must be a transformational document that moves towards the values that we hold together. With regard to your question, Niranjan, the Constitution isn't a Victorian artifact at all. It came into being in the 1950s, right? So it can't be. And also it's an independent, it's something that independent India created. Now, there were many choices that were before the drafters of the Constitution. Was it the music of and this is from the constitutional debates, was it the music of the veena that they were going to listen to, or the music of violence? But it's not as simple as that at all. It's some group rights are recognized, individual rights, yes, are there. But where we are today in our relationship with the Constitution is, as I said, quite different from where we began. With regard to women in the law, there aren't enough. There is a new bill that the present dispensation has brought in with regard to women's reservation in Parliament. It has been hooked onto sort of gerrymandering and electoral, lines being drawn, which are extremely controversial. So there's that, and it's not going to kick in immediately. So let's see what happens to that. I think that with the judiciary, with other kinds of participation, symbolism and participation for its own sake is fundamental. One must make sure that there is horizontal reservation, that it's not just women like me who are being benefited by this, that it is also women who are of other castes, trans women, and the horizontal reservation discussion is very much happening around the trans women's right to such reservation, and disabled women and other groups. However, I think we've all seen with Suella Braverman that representation isn't everything. You know? Like you could get someone who is a brown woman who maybe shatters some glass ceilings and then leaves sort of very sharp shards intentionally behind her. So we must, and I think, you know, we can hold two ideas at the same time. I mean, you can see that representation is important just on its own terms, and at the same time, that policy and the kind of policy that you make is also fundamental, right? Yeah. With regard to your question, like, look, it's tough, and I hear you. And I think if you look, for example, there are always arguments that you will have based on the particular country, based on the particular context. The colonial evangelical churches, for example, that the governments are not objecting to and appreciate, you know, that aspect of colonialism isn't a problem in some African countries, right? But I think most fundamentally, like when we are in these contexts and dealing with different kinds of intellectual and emotional assaults, then finding one's solid ground, taking care of oneself and those around us, and with grit and determination pursuing one's joy is in itself a deep and important act of resistance. Thank you.
Karuna, thank you so much. That's such an important note to end on. And look, there's no way I could possibly summarize what's been an immensely rich lecture and discussion. But what does occur to me, I think many of us who are not lawyers and are not part of the legal profession see law as often more rigid and unmalleable than in fact it is. And what's really come across to me, as you've spoken and as we've discussed, is how jurisprudence, constitutions, the way legal processes operate are products of history. They're products of political and social choices that have been made along the way. And they exist in this often ambiguous, often contested, but often quite congruent relationships with norm shifts in society. And just as many of us studying development think about policy and policy processes as political processes, where there's always more room for maneuver than you imagine, and where there's a personal and a political which comes into play. I think you've given us a really powerful picture of the opportunities as well as some of the limits of the law and legal frameworks as part of these bigger processes in a journey that's absolutely taken us from the very personal up to the most international. So I'd just like to thank you and ask for one more round of applause for really thank you. So thank you to everyone who's participated. Thank you to our online audience for your listening and your great questions. And those of you who are here, please do join us next door for some more informal conversation over drinks. Thank you, Karuna.